The Colorado Supreme Court ruled 6-0 this week in favor of Dish Network for firing an employee for using medical marijuana off-site. The decision sets a precedent in how companies implement drug policies going forward. David, you're one of our two illustrious attorneys at the table, so what did you make of the legal decision, and does it set a major precedent for companies in Colorado and possibly Washington?
Well, Colorado has a statute that only a few other states do. It's called the Lawful Activities Statute. And it says that in general, your employer can't fire you for engaging in lawful activity when you're not on the employer's premises and it's not related to your work. So the question is for Dish, this awful company that fired a telephone representative because he's got very serious medical problems and was using medical marijuana properly, was never intoxicated at work, but they fired him under their zero tolerance, zero intelligence cruelty policy. Their argument is, well, it's definitely legal in Colorado, medical marijuana. On the other hand, it's not legal federally. So the lawful activities statute says you can't be fired for engaging in lawful activity. Does that mean lawful under Colorado law, or does that mean it's what if you're doing something lawful Colorado, not lawful federally? And the Supreme Court 6-0 said, well, we're just going to read lawful broadly, that we're not going to, as they said, we're not going to engraft statutory language which says lawful meaning only in regard to Colorado law. That's a plausible argument. On the other hand, Colorado Court of Appeals Judge John Webb, who was one of the dissenters in below, the dissenter below, said, hey, this is a civil rights statute, so if there's any ambiguities in it, we should construe it broadly for the protection of civil rights. But the Colorado Supreme Court 6-0 went the other way. I'd say both are defensible, plausible legal approaches.
Penn, do you think this is the last we're going to hear about cases like this, especially as medical marijuana, even though recreational marijuana is just Colorado and Washington right now, medical marijuana is spreading throughout the United States?
No, it isn't. And I wouldn't be surprised if Senate Bill 1 or House Bill 1001 next year didn't deal with this precise issue. I can't see the General Assembly not letting this decision stand. They're going to have to go after it some way because we're talking about both medicinal marijuana and recreational. And they're also going to have to deal with the whole standard of what constitutes under the influence or intoxication in terms of trace amounts in your system when you show up to work. So this decision I don't think will stand, because I think you'll see a bipartisan coalition go after it right away and clearly try to define what employers can or cannot do, particularly with regard to the medicinal marijuana. This makes no sense at that point. So now you're saying if somebody takes prescription drugs and they show up and they're a little bit woozy or a little bit tired or whatever, you can fire them because they have really a significant medical problem, but they had a reaction to their medication that's been prescribed by a physician. This opens a door that I think the General Assembly won't want to stay open too long.
Natasha, Penn brings up a good point, because I think this particular case, you have a pretty sympathetic character, this employee. As David mentioned, he wasn't high at work or trying to make some sort of chronic back pain. He's a quadriplegic. He has significant issues. Do you agree with Penn that we're going to see some legislative work moving forward?
Absolutely. I think we'll see legislative work. I also think that certainly in my lifetime, if not much, much sooner, we're going to see legalization across the country for both medical marijuana and just legalization of recreational. As someone who's been diagnosed with MS and who struggles with this and is not at a point in my disease where I need medical marijuana, but I know many people who do, it saddens me to see things like this happen. That being said, employers on an individual basis can deal with their employees who might have medical issues, such as a defendant in this case, and people like myself who may have adjustments that they need in their work life that seem reasonable. So even though there is a Supreme Court case, so it makes it sound like a very final decision, individually business owners can make a decision not to do what Dish Network did.
Patty, do you think we'll start seeing some businesses come out and say, hey, this is the way it should be handled?
I certainly hope so, because as David says, Dish behaved horribly in this situation. You have an employee who was a good employee, quadriplegic. It's not like he was operating heavy machinery. He was on the phone. So he was not endangering anyone else. It was not something they needed. They could have worked within their zero tolerance policy to accept the fact that he was a man, this man was taking medicine for his condition, medicine that worked for him. So I would hope the first thing that happens is that companies say, let's think about this. Let's really let's take the employees into account. And I think we will see the legislature come through with some rulings on this, because you could not have a better poster child for the reasons to use MMJ than this employee.